first ECLA Online Learning Center session in 2021. My name is Martin. I'm the legal project manager at ECLA, based in Brussels, and today we will be talking about Brexit, especially from an in-house perspective, and we are today joined by Dr. Helena Raulus, who is the head of Joint UK Law Society's office here in Brussels. Helena, would you like to say a few words?
Thank you very much, Martin. My pleasure to be here. We have, of course, have had a busy Christmas this year, looking at the agreement, looking at what's included, what's not included. And just as a preliminary caution, I will be speaking today about the big picture perspective, what's happening with the new TCA, what is included, what's not. But our analysis is still ongoing. So I will try to be clear where we are, where we know what's happening, but also try to be clear that where we know that we need to know a little bit more. It is a complex text. It's a huge text, and we have a lot of people working on it. But hopefully today will bring you some clarity as to what's happening next.
Thank you. So to our audience, we have structured this into 5 larger topics. And then just as a preliminary note as well, this is geared more to be a Q&A session, meaning that we implore the audience to utilize the chat box, which is over here, to ask questions to Dr. Raulus. And then, so the 5 topics that we will cover today are legal services, the mutual recognition of qualifications, the right to give advice, data adequacy, and judgments. So we will take the questions as they come in, and then we will make an ad hoc decision, essentially, whether to address it now or whether to address it at a later point. So without further ado, I think we can start with the first part, which is legal services, and we've put the location of the agreement here, which covers specifically legal services. And for the first question, what is covered under this section?
Well, this is sort of one of those good news, not so good news information or news section. So because what we have in this section is that essentially legal services are covered with this agreement. It's one of the 4 or 5 big industries which have been specifically addressed in the agreement. So we are of course very pleased as the law societies that we have been able to get a mention in this agreement. So it's very clear that we are covered in here. It's also interesting, the provisions, they set out this regime whereby you have a right to give advice under your home title. So that's a huge leap actually in the FTAs. We've never seen this kind of provisions, home title provisions, in an FTA before. So we are very pleased about that as well. So that means that essentially under the agreement, it should be possible to give advice on your home state law and public international law. We'll come back to the EU law questions a bit later in our presentation. But of course, as we are now out of the EU, as the UK legal profession is no longer an EU legal profession, we have that limitation that we are looking at home title and or home state law and international law. Now, that said, it's so far what we've understood, it's a fairly symbolic move. This is of course because of the structure of the EU, and the structure of the FTA, how in these kind of FTAs, every member state can put in their reservations. So all these provisions are subject to member states stating their own limitations and reservations to this right. So as such, it does not provide anything hugely further than what we would have under the third country practice in any country. So essentially where we are in the situation is that we'd still need to look at every system. If you're a UK qualified lawyer, you need to look at every system as to whether you can give legal advice or not, and to what extent. Now, on coming to the UK, then, of course, the UK side is looking at this differently. We have a different regulatory system. Our regulatory regime is very open. So these kind of rights do exist in all three UK jurisdictions: England and Wales, Scotland and Northern Ireland. So in that side, it does not open up any new rights. So for us, it's sort of a win to have a legal services chapter. It's a win to have provisions on home state rights. But as long as the reservations apply, it does not have a lot of practical applicability. And that's just one of the consequences of moving from an EU type of single market system into an FTA type of system. The other issues that we are looking at, of course, very closely relate to the digital trade. What are those? Because especially now with the pandemic, we've moved all into an online environment. So the sections of digital trade are, of course, interesting for us as well. And what I would highlight is the mobility. Mobility is the visas, the short-term visas, the intra-corporate transfers. So there are some facilitations in this agreement, which is very good. I think generally on visas, you can have business visas under this arrangement, as well as then you can have the intra-corporate transfers, which would be particularly useful, I think, for the in-house lawyers. So what I was looking at these provisions, and our advice on it is that it looks like that there is a possibility to have intra-corporate transfers for those who are highly qualified for up to 3 years and trainees for up to a year. But these are the issues that we're still weeding out as to how the details of these regimes would be working.
But like you said, it's good to see that legal services is actually covered on the agreement, because there's not that many professions that actually were. I think financial services was the other one, but overall it's just a handful of services. So it's good to see that legal is a part of it.
Absolutely, and what this can do is it sets a standard then for future agreements that we can look into. So what we can look at is in a more global context on how legal services could be treated in free trade agreement frameworks, and that's really encouraging.
All right, and so let's go to the next question then. Is this new regime similar to EU agreements with other third countries already?
Well, that's where the answer is yes and no. No, to the extent that the legal services have received this attention, as I said, and in that sense, it's a very encouraging title. It also includes, with the reservations, that actually there are some interesting mechanisms there. If you read it further, that the member states cannot put any further reservations, so the reservations are now locked in. We have non-regression clauses in this agreement, so that's a really good thing. And in that sense, it goes a step further than the other agreements with third countries. But like I said, as the reservations lists, how we have been looking at it, it looks like very much that this is just repeating the same reservations as in any other agreement. So in practical terms, not yet. It does not yet take it any further than the other agreements. So with that respect, the answer is yes, it's very similar. And the logic here is very similar. So unlike the EU or the single market logic, where you have a broad right to do something, you always have to find whether you have specifically that right to do something. So we are now looking into, for example, to what extent this allows arbitration and mediation, which are included, but how do these provisions interact together? Not only indeed the provisions that say that you have a right, and then the reservations, but then how does it work with the visa mobility regimes, etc. So that's the analysis what we are doing. And in that sense, it's a very similar regime to the other third country regimes or FTA regimes that the EU has.
So speaking of visa requirements, we actually have a question from Rude asking whether intercompany transfers are able to replace the requirement of visa requirements, and where can people find more details on this intercompany transfer agreement?
Can I say in this respect that we've noted this, we know the basic principle that exists, but we will be posting more information on the website, on our website, Law Society website, when we have analyzed these provisions. We are currently looking into those country restrictions, and the intercompany transfers will be one of those issues that we are planning to look as soon as we manage to go through the country regimes. So unfortunately, I don't have an answer to you at this point yet, and I don't want to hazard a guess because I'm an EU lawyer and not an international trade lawyer, at least yet. But I can tell you that we are looking into this, and we will get back to you with more detailed information as soon as we can. So I'm taking notes of this.
So as Dr. Raulus noted, the website of the Law Society is an ideal place to get up-to-date information about any sort of specifics, because they are the authority who are most invested in actually providing adequate information.
Thank you very much. Very pleased to hear that. We try our best, and we indeed, it's the Law Society of England and Wales End of Transition. So you can put that into the Google, and then you can have access to all our advice.
So moving on, what is lacking from the TCA with regard to in-house lawyers or legal services?
Well, there are the two issues, what we have talked a lot about, the reservations, but maybe also with regard to visa regime, I would highlight a specific issue, and that relates to Schengen visas. Again, it's about the complexity on how EU has been arranged. So technically, you have a right to short-term business visa exemption. Essentially, you can stay in the Schengen area for 90 days within 180-day period, and it can be for tourism or business purposes. However, as in the EU, the labour laws fall under the national competence. So essentially, anything to do with paid activity, where you encounter taxation and labour law regimes, that's where you need to be careful. So that's another thing that we are now currently analyzing and looking into, is how does this exemption work, in particular with relation to services, because that's where if your client is based in the EU country and you're coming from the UK, how does this work? How does the visa exemption, to what extent does it work really? To the UK side, if you're providing services from EU to UK, in my understanding, this is easier because there is no such distinction of paid activity in the UK side. But these kind of things, these kind of details, be mindful of, that it is an agreement that contains a lot of good things, but then you need to be carefully reading as to what are those gaps that are left within the agreement, where the member states in particular have their own right to say something. And that's, of course, because this agreement, as you know, all of you know, it was expedited very quickly. You had to do this under EU competencies. So it was not possible, even from my perspective as an EU lawyer, it wasn't possible to get an agreement that would actually harmonize the Schengen visas for the paid activity purposes, because that would have encroached the member states' rights. So what I would look at this is, if you're looking into the agreement, looking into what the agreement says, go also in parallel then to that member state, if you're providing services from the UK, to that member state side, and see if there's any further information about what these member states are saying, what needs to be covered in a certain situation. Similarly, of course, going into UK, check the UK government sites as well for further information on how does this work in practice. We don't have much experience of this in the European context, so all of us are in a bit of a new boat here. But that's what I would say is try to keep an eye out on what happens also at the member state level, and have that clear conversation with the relevant either authorities or have a lawyer from that member state to explain to you how do the procedures really work.
So essentially, if there are gaps, just have a look at whether member states have some own specific rules regarding those specific gaps.
Exactly. And there are bound to be, because the EU can say only so many things. That's my example of the Schengen visas, that they can only harmonize to a certain extent. And after that, it is the member states' right to further regulate it. And as the UK is a third country, now the member states will have much more leeway on issues such as work permits, all kinds of residence permits, labour law rights, taxation. So always keep that in mind.
And then you already touched this a bit, but what about EU citizens looking to provide services in the UK?
The EU citizens looking to provide services, or EU qualified lawyers looking to provide services in the UK. The UK is a very open regime. In that sense, it's first of all, it's the visa structures are a little bit, or the visa exemption structures are a little bit more straightforward in the UK side, that you can actually go and engage in commercial activity. A good example is the legal services, what we are talking about here, and what's probably the most interesting thing for all of you, is that you can actually go into all the UK jurisdictions accept home title rights, so you can go and advise clients on home state law, on international law, on EU law, on to a certain extent any UK relevant laws as well. There are only very few reserved activities in each jurisdiction, where mainly these relate to how cases are run in the courts. So if you represent clients in courts, that's where you have different rules. But essentially, you can continue to provide legal advice in the UK. Information about this, of course, you can find from the relevant regulators' websites. So it's the SRA, the Solicitor Regulation Authority for England and Wales, for the solicitors, the Bar Council of England and Wales, or in Scotland, it's the Law Society of Scotland, or the advocates. And in Northern Ireland, it's the Law Society of Northern Ireland or the Bar Council of Northern Ireland. So go into those websites if you want to seek further reassurances. But essentially, for business purposes, the UK is an open jurisdiction. Now, what I would also like to say is that in the UK, essentially, you can, if you want to, you can still register as a something called the foreign registered lawyers. We previously had, of course, the registered European lawyers, but now we have and then we had the registered foreign lawyers, but now we have only the registered foreign lawyers. So if you're looking to carry on more permanently activities in the UK in any jurisdiction, you can register as an RFL, and in that sense, you can then get that full package of rights recognized under the system. You can also then get the regulatory support for your activities.
Okay, thank you. And so to our audience, if you don't have any other questions regarding legal service, or specifically if you do have questions, then we will come back to them at the end of the session. So now we will move on to the mutual recognition of qualifications, which is another big question, or a question that was lingering during the negotiations. And jumping right into it, because there have been mentions that the system will resemble the Canadian Free Trade Agreement system. So I'm asking you, what does this CETA model mean for mutual recognition of professional qualifications and for agreements?
That has been indeed one of the big points of debate between the EU and the UK. The UK wanted to include immediate recognition of the qualifications under the agreement, sort of a little bit continuing with the internal market model where we had automatic recognition of our qualifications. And to a certain extent, like we talked in our previous section, with regard to legal services, there was a symbolic nod to it with the home title rights, because that's part of it. But what we are also talking about when we talk about mutual recognition is the right to convert your degree. So this would be that, for example, I'm a Scots law lawyer, so what are my rights to become a qualified Belgian lawyer? Now, I'm not qualified, I'm simply an academic lawyer, but that would be the case. Now, what is in here in the CETA model? We ended up with that, and that was the EU's proposal. The CETA model means that actually none of this is included. The right to requalify is not included in the agreement, but rather there has to be a further agreement coming down the line. And this agreement would be then negotiated between the professional bodies. So we are looking to engage with the CCB, we are looking to engage with European bars on how to get that requalification route from a UK legal profession into a European EU one. And but rather than indeed having that right, that has been now stopped, the right. So the UK qualified lawyers are no longer EU qualified lawyers at this point. We now need to renegotiate that, and what would that agreement look like? After this has been negotiated between the professional bodies, so the professional bodies will draft the draft agreement. This will then be subjected to the Partnership Council. That's the decision-making body under the new CTA, the EU-UK agreement, which has power to make all kinds of decisions about the implementation, about the taking those further steps where further steps are needed under the agreement. So it's not going to be automatic. It may take a while. It's something that we need to embark on now.
But it is hopeful.
It is. We consider it hopeful, certainly. And again, maybe looking at it from the other direction, that if you're looking to qualify in the UK, you actually have routes. We are, with that respect, a very open jurisdiction as well. Admittedly, the route that was available before, that you have 3 years of practice in the UK, that's no longer available because that was part of the EU directive system. But you can requalify, for example, in England and Wales, by the SQE, that's the Solicitor's Qualifying Exam that the SRA, the Solicitors Regulatory Authority, they have adopted this year. So looking to wherever jurisdiction you're coming from, you can look into that SRA website, and then you can see what needs to be done if you want to requalify as a solicitor in England or Wales. Similarly, if you want to do that in Scotland, look into the Law Society of Scotland or Northern Ireland Law Society of Northern Ireland, or the bars, depending what you want to do.
And then, I mean, continuing with the same discussion, so what are the requalification paths outside of earning an additional degree from the EU side? So for lawyers wishing to still work in the EU?
Well, actually, it is very complex now because it is up to each national system in the EU side. So if you're a UK qualified lawyer wanting to requalify in the EU side, we have some old agreements, of course. One of them, the most famous one is, of course, with Republic of Ireland, and how the requalification between, particularly England and Wales, and Ireland, or Northern Ireland and Republic of Ireland, how do those degrees are recognised. The only thing I would just put here as a question mark at this point, because we don't have an agreement between the UK and the EU on the matter, there's a little bit of question mark hanging around as to whether then that Irish qualification and under what conditions that Irish qualifications would have an EU-wide application. So what is clear is that this right to requalify almost automatically from Law Society of England and Wales to Law Society of Ireland, Law Society of Northern Ireland to Law Society of Ireland, it's automatic. You can requalify. That's on basis of very old agreements, of course, between the common law systems. However, the question is that how can you then, if you are looking to retain your EU-wide rights, that's still something that you need to be then aware. So you might then need to be established in Ireland, in the Republic of Ireland, rather than do it from the UK. Mm-hmm. Now, in other systems, I know that there is a route in France on how to do this. But unfortunately, many other systems, including what I've heard about Belgium, the Netherlands, etc., you would have to restart your law studies and go to law school. So that's another 7-year route that you would have to do. And that's, of course, onerous. So this is why we are looking to start working as soon as possible on the mutual recognition agreements that would allow that right. And then we can perhaps see to what extent we can include the home title rights, which is most important for a lot of people, and then to what extent we can include the requalification rights. And then the third question is to what extent is it possible to think in terms of the single market, that you have then an EU right on top of it. So it's a bit of a layered structure with regard to requalifications.
But there are pathways for the third wave of interested people that seem to be promising. Like I mentioned with Ireland and France, it seems that there are certain pathways that, it remains to be seen in practical terms how it will unfold. However, for the first wave of people, it does seem that there are some options.
We are exploring how these options will be working indeed in practice. But what I would say is looking to it's unfortunately the answer is looking to the national system and think in terms of what could be available. Actually, we had a big campaign before trying to already incorporate those people who had been working across the borders, so coming from the UK, working in the EU countries, trying to get them into the EU law qualification regime under the withdrawal agreement, the transition period arrangements. So we were very, very consciously working on that because we knew that there would be a risk that there is now a gap when you don't have a clear route to requalify, when your status actually, even if you have a requalification and you attain it now, your status could be under question mark. But we are working to solve these questions, and we do recognize that in that sense, the reality is now much more complicated, especially for those people who are looking to still practice in an EU level. Mm-hmm. And we'll come back to that a little bit later as well, what that truly means.
Okay, and so the next topic that we have is the right to give advice. And jumping right into it, so what are the requirements for solicitors to give advice in EU member states?
Well, as we said, the TCA gives technically the right to give advice on home state law. So that would be, for example, solicitors of England and Wales can talk about UK, to a certain extent UK, and then English and Welsh law. So that's there, plus then public international law. But that is under reservations or subject to reservations. At that point, you really need to look at each system, what is available. So there are systems such as, for example, Belgium. Belgium is very open. Giving legal advice is not restricted under national law. So we don't see that changing. The TCA does not change that in any way. But rather the right to give advice, legal advice in Belgium is retained because that's what the national system allows anyone to do. You don't even have to have a law degree or be a lawyer, but you can essentially ask advice from your hairdresser if you want to, and the hairdresser is entitled to give legal advice. So that's it's a example of a very open system. Then in other systems, you do have restrictions. I think Greece has been traditionally the most restrictive. So they're giving legal advice if you're not a qualified Greek lawyer or an EU lawyer is actually a criminal offense. So you can see that there's a high penalty attached to it. So essentially, it depends on the regulatory regime. It can go from anything from being able to give advice to not being able to do really anything. It depends on the national regime under the TCA. So essentially, we are looking beyond the TCA now. We're looking into those reservations. We're looking into the application of the national regimes, and of course, then trying to work out with those corresponding regulators in the other European countries as to giving advice what is possible. Now, there's another layer, and that's then the EU law and right to go in front of the EU institutions. I think that's our next question. So
it's the question after this.
Okay,
and we can jump just right into it.
Sorry, yes, I'm reading my notes here. So essentially, in front of the EU institutions and the right to give advice on EU law, now that's something that does not exist in this agreement. In a national level, we don't think it has any implications that it doesn't exist. So, for example, if you're in Belgium and you're advising your clients on I don't know, UK law, and then there's an EU law aspect, as giving advice on EU law is not a restricted activity, or any law is not a restricted activity, you can still do that for national purposes. But as soon as if you represent those clients in front of the EU institutions, if you don't have a EU qualification, you don't anymore have that legal professional privilege, or you don't have that right to appear in front of the EU institutions as you had before. So that's something that's really now outside of the scope of this agreement, certainly.
So it remains to be seen.
It remains to be seen, and it remains to be then agreed. That's where the requalification route becomes very important.
And so the other question that we had under this topic, I think we were ready to address regarding any restrictions with the scope that solicitors can now give advice. So it all comes down to the national regulatory measures that are in place.
Yes, exactly. So we are working with the other European bars to be able to identify what those are.
Mm-hmm. And then our the next topic that we have is data adequacy, which is another highly contested issue that is essential to not only the agreement, but any agreements that either the EU or the UK has with other countries. And we've added some notes here. Essentially, the trade agreement does have a grace period, and it ends either after 4 months, that can be extended up to 6 months, or when the Commission reaches a decision that the UK's regime is adequate for EU data transfer. And so the first question would be then whether personal data can be transferred freely during the grace period, similarly to when the UK was a part of the EU.
Yeah, what we have is a so-called breaching provision, or like you say, grace period. So this means that everything continues when it comes to personal data, data flows, exchange of data, everything continues as it did before. So it became clear as the agreement came out so late in the day, Christmas Eve, as we all know, there was no time for the EU to take a decision on data adequacy at that point anymore during 2020. And that would have caused, of course, a disruption on data flows. So rather than trying to push that decision, because that decision is not simply the Commission, it's through the comitology procedure where you have to involve the Council and the Parliament. So rather than trying to push that agreement when everybody's already on Christmas period, they adopted this grace period or bridging provision. Now, it wasn't possible for the agreement to contain a stable data flows provision either. So that means that essentially there were some discussions around it whether the agreement could contain data adequacy provisions already, but as data adequacy processes, they are now really delegated in that data protection regulation to the Commission and to the comitology procedure. So in that sense, having this kind of agreement would go against the data regulation. So it's another consequence of the UK becoming a third state outside of the single market, that we now have to look into the data adequacy provision. So that's a little bit of the reasoning why there is the data adequacy provision, the temporary data adequacy provision in this agreement. But while this decision, or while this temporary period is running, everything continues the same. And we do have an expectation that the EU will be preparing the data adequacy decision during that period. That's the expectation at the moment. Mm-hmm. We will see, of course, how it proceeds, and there are some question marks on how to do this. Because of course we see the developing case law from the Court of Justice on what is required for these data adequacy agreements. So there is still quite a bit of work to be done. But as the signs are, there is a political expediency to get this done. Mm. It's not only it doesn't only benefit the UK side, it benefits the EU side as well to have an agreement on this.
Of course. But looking at the worst case scenario, what happens if this adequacy status isn't granted? And I mean, how likely is it to happen?
We'll see when the political debate starts. Essentially, like you say here on the slide as well, it doesn't affect the UK side. You can still share the data from the UK side to the EU. Where the disruption would come in is sharing EU data.
Hello? So it seems that Dr. Raulus has disconnected. Just a moment. So, you're back. Wait, your audio is a bit now off. Your microphone input. So let's try again. Can you try now? It's still rather bad, as if the microphone is very far away. I think the microphone in your headset has shut off. Okay. No, now we cannot hear you at all. No, there is still no sound, unfortunately. Can you hear me? You can hear me, but we cannot hear you, unfortunately. Can you try replugging? Can you try replugging and then just see whether that will help? No, we still cannot hear you, unfortunately. Dr. Raulus, I think there is something with the audio setup that you have. I'm not sure whether the microphone, you will rejoin. Okay, so we'll take a 2-minute break. I'm sorry for the delay. I hope we have it figured out. So after data adequacy, we will have one more topic, which is judgments. So I do hope that you will stay here, and I'm pretty hopeful that we will have the situation fixed shortly. Hello? No, we still cannot hear you, unfortunately. I'm pretty sure that the microphone input is switched off. I'm not sure whether I can help you directly through here. We can hear you, but very, very vaguely, so not clearly at all.
Okay. About
this is still a bit too hard to actually understand.
Yes. Just one.
Mm-hmm. Yes. Now.
Okay. Apologies. Something weird happened with the connection.
Yeah.
As these things do. So where were we?
Yeah, 2021 isn't still kind to technology, for better or worse.
No. At least I'm starting to be more relaxed about it, because there's this.
Can't help it.
No, you can't help it. You can just try to think.
Too rush. Yeah. So coming back to data adequacy, and if the adequacy status isn't granted to the UK.
Yes. So in that case, we go back to that no deal scenario, where we would encourage you looking into the standard contractual clauses, making sure that they are in your agreements. This is really applies only if you have indeed sensitive data going from the EU to the UK side. The other way, it's not as problematic as is set out in here in the on the slide. But that's why also we have kept, when we revised the guidance for our website, again, the Law Society of England and Wales website on end of transition, we have kept that data adequacy advice still there, saying, okay, keep an eye out on it, whether and how long this transition period, now we are in another transition or extension period on data, how long does it apply, and whether the European Union data adequacy decision is coming. So we still retain that old no deal advice on data still on our website, because 6 months is a short time to have a data adequacy from the EU. We do hope and think, as I said, the political expediency of it hopefully makes the parties to helps the parties to agree on this. However, if there's no agreement, then look into put in those alternative formats if you have a lot of data going or any data going into the UK side.
Mm-hmm. All right. And the final topic that we will cover today is judgments. And going right into it, what will govern the judgments between member states and the UK in a post-Brexit regime?
Well, there's nothing in the TCA about it. We knew this. This was predictable. We knew that the EU did not have a mandate to talk about the judgments in civil and commercial matters. So in that sense, we knew that this treaty would not be responding to that. However, what we hope now that there's the agreements between the EU and the UK, that this would expedite indeed the EU finding the solutions in this area. So at the moment, because we are in a gap and there's nothing in the agreement, what happens is that if you start any new proceedings, cross-border proceedings, you have to look into national law. That's the primary source, national procedural law, which court has jurisdiction, how does the recognition enforcement proceedings, how do they operate? So you do need to engage with the local lawyers as to how to run these cases and how to get the best possible solution for you. Now, there are some cases where there are the old bilateral agreements, possibly the UK Netherlands is enforced because that has been enforced between those parts of the Netherlands Kingdom that are not EU territories and the UK. So possibly that agreement, bilateral agreement, would be available to facilitate. However, in most cases, you would have to ascertain that this agreement has been enforced and continues to be enforced between the UK as well as that other country. So the UK-Germany agreement, we know there are question marks because it does not, in legal sense, it does not exist anymore. It's been superseded. It's been overridden by the EU regulations, Brussels 1. Mm-hmm. So it would have to be revived, and it hasn't been, as far as we know, revived. So those are only very limited help. And in that sense, my advice is really looking into national law. Mm-hmm. Final choice that you have, and that's if you have an exclusive choice of court agreement, you may be able to use the Hague Choice of Court Agreements Convention from 2005. Now, it only applies where you have an exclusive choice of court agreement, so it does not apply where the agreement is hybrid. So you have one part of the agreement that would be litigated in the courts of the country A, another part in courts of the country B. That's probably outside of the agreement. Similarly, if you have a combined litigation arbitration clause, in that case, you would have to go back to national law as well. The Hague Agreement Convention does not help you. Just the thing to note about this is, and that's the practical advice maybe that I can give you a practical hint, is that there's also a dispute now between the UK, the Hague Conference, and the EU as to what is the effective date of entry into force of that convention. So this is important because only if a choice of court agreement is agreed before choice of court agreement is agreed after the entry of the force of the convention, it falls under the convention rules. Now, the EU became party on October 2015. So the UK, for the UK purposes, the effective date is October 2015. So if your agreement is dated after that, in the UK side, it's recognized as falling under the Hague Choice of Court Agreements Convention. Similarly, that's the view of the Hague Conference on Private International Law, that should be the effective date. If you look at the statutes table, it says that that's the entry into force date. Now, in the EU side, the European Commission has said that, well, for them, the effective date of entry is the 1st of January 2021, because that's when the UK entered as an independent party to that convention. So essentially, in the EU side, it might be that some national courts would be following the Commission, some national courts may be following the Hague Conference. We don't know. It may be that in time there will be a case to the Court of Justice that can decide this, that can make the decision, of course, in the EU side. But there, if you're looking to include the EU side, I would say as a practical hint is to look into your choice of court agreements now and try to get them repapered or reconcluded so that they are exclusive and then they actually fall under the scope of the agreement.
Okay. And then the next question would be, what are the solutions for the recognition and enforcement? And then what are the timescales under which these solutions can be adopted? I mean, you've already touched this, but maybe you have some additional things to mention.
Yes. Well, we do hope that there will be solutions, because falling back on majority of cases or using the national procedural regimes, it is clunky. You can see today the FT, for example, quoting this, that this is going to be it will cost time and money essentially then to litigate these cross-border cases, time and money that a lot of companies have not been essentially investing on this problem. So we do hope there will be a solution. And of course, the obvious solution that we have is the Lugano Convention. That's a convention between the EU and the EFTA states. It's sort of a parallel regime to the Brussels I Convention. Our membership has been very keen on continuing in this convention because, well, it's a known quantity. It's known how it works. It's been operating since 1990s. It's as it repeats mostly the structure of the Brussels I regulation. It provides that same kind of security that first of all you have a forum, you have rules on where to litigate, but as long as you use those rules, you have that benefit of the security that then it is almost automatic that this judgment will be enforced. So that would be the first solution, at least for our members. If that doesn't work out, we have, of course, the Hague 2019 Judgments Convention. That's a little bit different option. It's a very new convention, so we don't know how it would operate because it actually is not in force at the moment. It's only signed in 2019. It does not contain those jurisdiction rules, so that's something that we would have to then work on in the future as well. And it has some key issues carved out, such as competition claims or IP law claims that the Lugano does. But of course, it does provide for that broader recognition. And in most businesses, you are, of course, using choice of court agreements. So this would encompass also the much more complex choice of court agreements structures in it. So it could be then, if Lugano Convention is not to be agreed, the Hague 2019. Now, the choice on this, it lies in the hands of the EU at the moment. The UK has applied to the Lugano Convention last spring, but the EU has not said whether the UK can accede or not. And essentially, we are expecting that decision to come out actually fairly soon. The Lugano Convention says that the parties, that's the EFTA countries, EU and Denmark separately, because Denmark has an opt-out, of course, they have a year to indicate whether they want to accept or deny the accession. Mm-hmm. We have from the EFTA countries, they've already said yes, but EU and Denmark, we're still waiting to hear from them. And we hope now that they will indicate early this year whether their view is positive on this. So we have a timescale. If the decision is positive, it can actually be implemented very quickly. It's a very easy ratification process at that point.
And just to stress, if they are accepted, then the Lugano Convention would be the most convenient way to actually address this question.
At least from the perspective of our membership, it is, because it is a known convention. It applies very widely. It's something that everybody knows how to work with.
Mm-hmm. Exactly. There's precedents already.
Exactly. It's been operational, so we know what we get and what we don't get, and that's indeed the next question. The differing from yes.
So how does this agreement actually differ from the EU regime?
The Brussels I EU regime. There are two issues in particular to note here. One of them is lis pendens, and that's when you have several courts in the different contracting states that have seized the claim. So the parties are bringing these actions in different courts. In where you have a choice of court agreement, the Brussels I regulation actually says that even if the court is second seized, they can continue. They don't have to wait for the court first seized to make a determination of the jurisdiction, because it's clear that it's their jurisdiction. In the Lugano, we have the more older provision, which says that the court second seized, even in a case of choice of court agreement, has to wait. So that's of course something that a lot of members keep pointing out, that this is a considerable difference. And then we have the second issue is the enforcement. Under Brussels 1, you don't have to have a declaration of enforceability anymore. The presumption is that you can just enforce it. Mm-hmm. Whereas under Lugano, well, it's an international convention, so you need to have the declaration of enforceability in the courts. Mm-hmm. Now, this is more of a symbolic nature, the second one, because the point here is, like with Brussels 1, the Lugano allows almost automatic enforcement in any case. It's a more of an administrative or a more a decision that the courts would automatically take. So what is our anecdotal evidence about this point is that actually, if you have Brussels 1 or Lugano in place, you don't even often have to do that enforcement action, because everybody knows that it will be enforced, exactly. So the judgment from the court of origin is already respected in that sense. And that's the big issue that we are now, of course, during the gap, we are battling, that these kind of things, the national law opens up a lot of challenges, possible challenges, and in that sense, the enforcement proceedings, actually, there might be a will for some parties to start questioning the enforcement and questioning the judgment of the origin. And here it doesn't matter if it's a UK judgment coming to EU or EU judgment going to UK. It's the same situation on both sides, because in both sides you would need to have that enforcement action, and through that action you may use some national law grounds to open up the judgment and create uncertainty, essentially legal uncertainty, and indeed time cost. This costs a lot of time and money for the parties.
Mm-hmm. Of course, and so now we've come to the end of this presentation. I'm just going to see if we have some more questions coming in. And in the meanwhile, I would like to thank you, Dr. Raulus, for joining us and providing such an on the ground experience and viewpoint from this highly contested and highly difficult negotiation that has been taking place now for the past 5 years. So it is interesting to actually see the finish line now, or you already surpass it, and then still see how much still needs to be done. So I would like to thank you for taking this time. And as Dr. Raulus noted again, I would like to note to the audience that for latest Brexit news, you can always just Google Law Society End of Transition, and the first hyperlink that you get there is the place where you can actually get the most, the latest news on this.
Thank you, Martin. Thank you, Ekla, for having me. And if you have any questions, happy to take them further. I will take it to my team that we will explore the intercorporate transfers next and post some information onto our website. And maybe, Martin, I can then send you that information as well, because I appreciate it's something of importance to the in-house audience.
Absolutely, we're always happy to distribute, because this is the function of ECLA.
Thank you.
So, thank you once again for everybody joining, and we will be updating our list of speakers soon. So tune in to our website to actually see when the new speakers will be posted. And then feel free to check out our other activities as well. For example, our Corporate Counsel Academy that we have launched, which is now providing certificate courses for in-house lawyers. And this can be found by going onto our website as well at ecla.eu. So I would like to thank everybody once again for joining, and thank you, Dr. Raulus, for taking your time. And I hope to see you all again soon. Thank you. Goodbye.